question from Senator Carter.
I'll be brief. This is a bad bill. And let's go through why it is. It's always been the law of Louisiana, at least going back decades before the Louisiana Supreme Court, that if a claimant had no prior history of illness, injury of any sort, and then a tortfeasor comes along and causes an accident, that there's a presumption that a person in good health then has an accident and then later has injuries, that there's a presumption that the accident caused that person to have injuries. How is that now a problem if that's been established Louisiana precedent going back? The earliest case I found, I think, is the mid-'70s from the Louisiana Supreme Court dealing with this issue.
Yeah, Senator, so part of the civilian tradition that we have is that we're constantly, as a legislative body, looking at court decisions and determining whether those decisions are still, valid, whether they should be reviewed. It's our duty as a legislature to address and correct these things that if you believe they're incorrect. So just simply, and simply because something has been there doesn't mean in our civilian tradition that it is.
I can't recall a civil trial that I've had, and listen, I do plaintiffs and defense work. It's about 50-50. I've been a defense lawyer way than I've been a plaintiff's lawyer, and I can't recall a trial where a Housley presumption or a Housley instruction was not presented to the court. So even though it's well-settled Louisiana jurisprudence, it's in effect almost every day. Every time we go to pick a jury, there's the Housley presumption, there's the instructions to the jury, conversations with the judge, the other lawyers, and it just seems basic. If a person had no injury, no prior history of accident, and of course there's discovery, so the defense lawyers can issue subpoenas, find out the person has no medical records of any problems with their neck or back or headaches or whatever it may be, then there's an accident and those symptoms manifest themselves. That just seems to be going against Louisiana's tradition of you take your victim as you find them. If you find a victim, if the tortfeasor causes an injury, causes an accident, and the person never had another accident, and that person then has injuries, that just seems fair. This legislation, the way it's drafted, I really have some concerns because this is what it states. The lack of a prior history of an illness, injury, or condition, here's the most important part, shall not create a presumption that an illness, injury, or condition was caused by the act that is the subject of the claim. Shall not create. So that instruction is now going to go to the jury. So instead of being able to tell the jury, if you have a person, based upon Louisiana precedent, who has no prior history of of illness of any sort, then there's an accident and the person then has injury, it's a presumption that it caused it. Now the jury is going to be told that it shall not create a presumption. So you're going from 0 to 100, a complete opposite reversal of what is in the benefit of injured Louisiana citizens. And I'm just struggling why we would take that away from them.
Yeah, Senator Carter, look, you're right. This does flip the burden, absolutely. And it brings it in line with, if I'm incorrect, please correct me. I think, in my experience, this is the only situation that I am aware of where the burden of proof, it may be a left-turning motorist. There's a presumption that a left-turning motorist is at fault. There
are all sorts of presumptions. If you rear end someone, there's a presumption of liability. So forth.
When it comes to medical causation, though, let me rephrase it that way. This one just simply puts the burden of proof onto the plaintiff. They have to prove their case. They have to, when you're going through the but-for analysis and all of that, it's part of that. There's nothing by removing the presumption. They're still able to prove it. And if you're correct, if they did not have any prior injuries or anything like that, a doctor would be able, or an expert would be able to say that this is.
But you're watering down the word of the testimony of the witness. If the witness, so yes, that witness will either testify in deposition or at trial. That plaintiff will testify at trial or in deposition. I never had any prior accidents. it can be impeached. It can be cross-examined. There'll be a right to go get prior medical records. There's a right to go see whether or not that statement is true. And if that statement is true, if the evidence shows that this person has no prior accidents, no prior injuries of any sort, then this accident happened, and the evidence before the court, the testimony from the witnesses, there's an onset of symptoms, yeah, that's just fair. Well, your law says that even if that's true, the evidence shows no prior injuries, the evidence shows that here's a tortfeasor, and the evidence shows there's a manifestation of symptoms, you want the instruction to the jury is that shall not create an assumption that that accident caused the injury. Now you're going to make it harder for the plaintiff. Now the burden is going to be on the plaintiff. It's not just good enough to not have medical records of a prior injury. It's not just good enough to have unimpeachable testimony that there wasn't a history of an accident, but now that plaintiff is also going to need an expert to come further testify that this accident caused the injuries being complained of. That's going to result in an increase in litigation costs. That's going to burden down the system. That's going to result in every time there's a dispute of medical causation and we can't rely upon the plaintiff's word, we have to file suit, engage in discovery, engage in expert discovery, increase it. Like I said before, I just think this is a bad bill. That's it, Mr. Chairman.
Senator Luno.